Then,
repeat it, please. Come again.
after all your advocacy and your listening to the tape and coming to the conclusion that the Attorney General had misconducted himself, even including criminal implications, and you refer to a precedent where an Attorney General suffered in a like fashion, you said he should either resign or he should be dismissed. The court has determined this matter. What do you say?
Thank you, and good morning. I don't think the court has determined the matter. There was an attempt to do a mini trial, that is a trial within the main trial. And that application says that the substantive case is still ongoing. But having said that, I think that we need to understand how the judicial process works. If a judge has jurisdiction, that is competent to try a case and come to a verdict, the judge can go right and can also go wrong. So if you have jurisdiction to do right, you also have the jurisdiction to do wrong. That is to give a positive or a negative verdict. Now, having listened to the tape this morning for a third time, I think that the Attorney General is not doing justice to the whole nation. Mind you, the Attorney General, under our Constitution, is the guardian and protector of the principle of justice. So he's the guardian and defender of the public interest. Now, here we are. If you listen to Richard Jakpa, he kept saying to the Attorney General, you and I, we've been discussing this matter at my cousin's house. You and I, we've been discussing this matter at my cousin's house. He doesn't tell us the number of times that the Attorney General, Godfred Dame, and he, Richard Jakpa, met in Jakpa's cousin's house. By the number of times, that is one. Then in the course of the conversation, which was in a private conversation between the two of them, we hear Richard Jakpa say, ask the Attorney General, how you want me to do what you're bidding, how I go about answering questions, how I should go about answering questions. My brother, this amounts to coaching, and it's a serious offense under our law. It amounts to contempt of the court. It amounts to obstruction of justice, which is also a criminal offense under our law. Under the Constitution, any such offenses amounts to contempt of court, for which the Attorney General can be attached. I'm surprised that the defense has, up to now, not brought an application to attach the body or person or the Attorney General. Let him face the wrath of the law. What he has done is contempt of court, pure and simple, and he must be made to suffer for it. Then in the same conversation, Richard Jakpa reminds the Attorney General that I, Richard Jakpa, am innocent, and therefore I wouldn't do anything that will incriminate an innocent person merely because you want incarceration for that person or because you want your prosecution to succeed. I won't do that. He kept reminding the Attorney General. Now, arrogantly, the Attorney General comes to tell us soon after the court ruling that all the public comments, the commentators have misled the general public. It is he, the Attorney General, who has misled the court. And if we were operating in a different system, the judge would have cited the Attorney General for obstructing justice in the court, which itself also amounts to contempt of court. We have what we call in law contempt ex facie curiae, that is contempt committed before the court. So the Attorney General has tampered with a witness, and in criminal jurisprudence, we also have what is known as witness tampering. Witness tampering is any conduct of the prosecutor or defense to influence or intimidate a witness to go one way or the other. Is the Attorney General seriously suggesting that what he did not or does not amount to witness tampering?
Right.
In my considered opinion, his conduct amounts to witness tampering, and that is also contempt of court.